Okay, oh, yeah. I think you can hear me, right? So good afternoon and welcome. I am Leslie Gerwin. I'm the Associate Director of the program in Law and Public Affairs here at Princeton University. I also have the honor of teaching in the American Studies program here and at the Benjamin Cardozo School of Law in New York City. It is my privilege to welcome you here on behalf of LAPA to our annual John Marshall Harlan Class of 1920 Lecture in Constitutional Adjudication. This event was established by the former LAPA director and now president of Princeton University, Christopher Eisgruber, to celebrate the legacy of the 8th Supreme Court Justice who was a Princeton alum. And in case you're wondering, current Justices Samuel A. Alito, class of 1972, Sonia Sotomayor, class of 1976, and Elena Kagan, class of 1981, are respectively the 9th, 10th, and 11th Princeton graduates to serve on the High Court. Now, following a recent tradition, today's program features a distinguished panel of individuals whose professional careers are in large part involved with analyzing and reporting or writing on the constitutional adjudication of the Supreme Court of the United States. Now, this is actually the 4th time that LAPA has convened what we call the full court press, the Supreme Court, the media, and public understanding, in proximity to the first Monday in October when the court begins its new term. We invite reporters and analysts to share their thoughts about the cases and controversies, both during the previous term and what we might expect in this upcoming new term. We seek to learn what they will be watching, and through your questions, to gain an insight into issues of concern to you and to the public at large. Ironically, our thinking behind the first program 8 years ago was that unlike the legislative and executive branches, press coverage of the judicial branch rarely attracts the public's attention, such that the role of the judiciary is often undervalued as part of the American system of checks and balances. Now, admittedly, the events in recent weeks, including the riveting nationally televised hearings on the nomination of our newest justice, belies the assumption that SCOTUS is not making news and people are not listening. So it's fair to say that the high-profile cases and issues, both those associated with the justices as individuals and the cases they decide, sometimes obscure or distort public perceptions of the less flashy but no less consequential cases and controversies that will impact and preserve the preservation of our democracy. So today we are delighted to welcome 3 experienced and nationally recognized court watchers who are notable for their knowledge and wise analyses about the Supreme Court's history, personalities, operations, and decisions. Now, the biographies of the participants appear in the program card, so I will not repeat what is there. Instead, I will briefly introduce each panelist by highlighting a few additional, but by no means complete, list of their accomplishments. I will do so in the order in which they will give their opening remarks. We will then allow them to engage in discussion with one another, as well as with you, the audience. So I am first happy to welcome back to the full court press Jess Brovin, who covers the Supreme Court for the Wall Street Journal. He has formerly worked as a United Nations correspondent, authored 2 books, including The Terror Courts, an award-winning account of military trials at Guantanamo Bay, and Squeaky, The Life and Times of Lynette Alice Frum. And for those of you who are too young to remember, she was a member of the Charles Manson gang who attempted to assassinate President Ford. Jess is a graduate of Harvard College and the University of California, Berkeley School of Law. Next, we are delighted to welcome to Princeton Marcia Coyle, who serves as the chief Washington correspondent for the National Law Journal, where she has worked for over 20 years. She is also a regular analyst of Supreme Court news for PBS NewsHour and author of the book, The Roberts Court, The Struggle for the Constitution. And I believe I recently heard you on NPR as well. So Marcia has a BA from Hood College, a master's in journalism from Northwestern University, and her JD from the University of Baltimore School of Law. And last but not least, we welcome to his second Harlan event, Professor Jed Sugarman, who teaches at Fordham University School of Law. He is the author of The People's Courts, Pursuing Judicial Independence in America. And in addition to winning several awards, it was cited in a Supreme Court opinion by Chief Justice John Roberts to rebut a historical claim of Antonin Scalia. Good work. Jed has co-authored the historian's amicus brief in the emoluments litigation against President Trump. And if you tune in to the nightly news analysis shows, you might catch Jed offering a cogent legal analysis on a legal issue of the day. He received his BA, his law degree, and his PhD in history from Yale. So welcome to all three of you, and Jess?
Well, Leslie, thanks for having me back. It's certainly great to come to this beautiful campus, but it's also, for those of you who don't know, the backcountry of Dow Jones, our publisher, the Wall Street Journal, just up the road in South Brunswick, is a massive complex, known officially as the Barney Kilgore Center, where, among other things, there is a small museum of the journal's history from 1889 forward. So if people are interested in seeing those old ticker tape machines and the great bulletins and all the fascinating moments of journalistic history, it's worth arranging a tour. So thanks very much. And also on that note, our former publisher Peter Kahn started the Princeton Packet. So there's a lot of history for our company in this area. The Kavanaugh hearings obviously got a lot of attention, and there was a lot of focus on his own background and views and behavior. But with him joining the court, I think that it's worthwhile to step back for a moment and look at what is happening more structurally there. And we really are seeing, I think, the opportunity to tell, without suggesting Marcia's title was premature, what the Roberts Court looks like when Chief Justice Roberts has a majority of solid, conservative jurists to work with. That's something that, in the minds of many conservatives in our country, has eluded the Supreme Court, even though, since 1969, Republican presidents have appointed 14 of the 18 justices. That the idea of a court that was consistently conservative and able to construe the law in accord with those principles as a counter in some ways to the more liberal court that really dominated the country in the 50s and 60s and still animates the imaginations or nightmares of law professors, depending on their perspective, the Warren Court. There hasn't been a court that could move consistently in a conservative direction. Now there may be for the first time, because Justice Kennedy, who has retired, while conservative in many ways, and someone who was the personal lawyer for Ronald Reagan when he was governor of California, did depart from both the method of other conservatives and the results in certain cases, high-profile ones, obviously gay rights and death penalty and some other areas. So when we look at what is going to be happening in the future, the question is, now that there is a fairly solid majority, what does it want to do? And what areas of the law will we see changing, and which ones will we see being further solidified in the years ahead? So far, the current term won't give us much of an idea about that, because the cases that are on the docket are fairly mild in terms of their broader consequence. Obviously, they're important to the litigants involved, and they do touch on some important issues. And already they've given us some clues about how the new justices, Kavanaugh and Gorsuch, approach some issues. But overall, we're going to have to wait to see what comes down the pike from as the year unfolds. We also have a very unusual situation in which the court, as Leslie suggested, is viewed and is involved in the political arena in a way that I think most justices might find uncomfortable. Both the confirmation battle itself, the way that certainly President Trump made appointments to the court and outcomes in specific cases very central to his campaign message. The incredibly bitter and brutal struggle in the Senate over the last 3 nominations. There was one that didn't quite make it to a hearing, Merrick Garland in 2016. Those things all put the court in a much more political light than I think they like to be seen, and how that affects both the election next month and how the outcome of that election affects the role of the court and the stature of the court, I think is going to be something very interesting to see. So those are some of my broad thoughts. Should I keep going, or have I overstayed my welcome?
You could do a few more minutes.
Okay.
But leave something for the rest of us, too.
Yes.
Oh, all right, I'll try to shoot. So the cases that, all right, the cases that we have this term that I think we started looking at, it was actually quite a remarkable thing because, Marcia and I, we have cubicles next to each other in the Supreme Court press room G43, and we were also took a rare walk across Constitution Avenue to the Senate buildings for the Kavanaugh hearings, and the kind of intense, brutal rhetoric and the scheming and this and that. It was sort of amazing. And then you go back across the street for the first week of arguments at the Supreme Court, and it's like you've stepped off on Mars, and it's a completely different atmosphere. There are totally different vocabulary, a different language. It's as if the Supreme Court is operating in its hermetically sealed marble building and just pursuing the normal, carefully worded questions and issues that come before it. So, the cases that we have involving sentence enhancement for the Armed Career Criminal Act, even seeing in the second week Brett Kavanaugh taking up the empty seat on the far right end of the bench. That's just a coincidence. That's where the new justice sits out of the seniority order. Seeing that seat empty the first week of arguments and then filled the second week, and he is treated as if he's been there for 1,000 years because it's Justice Kavanaugh, it's this, that. He's asking questions that are exactly the sort of questions that a prepared judge would act, as if all that stuff that took place across the street never happened. And I think it is worth pondering whether that's a good thing. Maybe that is actually a very good thing for the court to get back to its work and try to isolate itself from the political currents. Or is it kind of an act for everyone to pretend that none of that stuff ever took place? I don't know. I'm just sort of observing it, and there was a real element to the way things unfolded. In fact, I don't know. What's another word for dull that doesn't sound like it means boring?
Interesting.
Yeah, I have a very interesting personality.
Routine.
I've been told. Yeah. So the first argument, Justice Kennedy was there to sit in, but I think even he sort of began to think, hey, they're not paying me to be here anymore, and he took off afterwards, and we haven't seen him back since. So for whatever interest he may have had in what the Supreme Court does and what his 2 former law clerks might have to contribute to the argument, I think he was happy enough to listen to Marcia on the radio talk about it than to have to sit through those arguments himself. So that's another interesting dynamic, and whether the court can maintain that distance, whether, we can assume that it's probably how much it works in their private conference once or twice a week when they all sit around the table and in a formal way discuss the cases and their outcomes. I would be stunned if there was even a hint of a reference to the kind of antics that took place in the Senate for the confirmation hearings. And that has been a norm established for many decades in this country. One thing to wonder about is if the kind of erosion of these norms, these unwritten rules that our institutions have, we've seen erode in the executive and legislative branches. Will that happen at the Supreme Court as well? And will that affect the way that court operates? I mean, those are some of the bigger themes that we're watching, even as we are all very, very eager to find out whether Weyerhaeuser Company gets to drain that puddle with the endangered frog, which was, of course, the first case that the court heard involving an element of property rights, and a case which I was reminded I did get to say that Justice Kagan leapt to the frog's defense during the argument, but my discussion of whether the fact that the company didn't appear to care whether the frog croaked was not, somehow didn't make it into the final version. So.
Isn't that's the drain swamp case?
Yes, it is. That did come up. And again, to show you, that's a great point, Jed, because during this argument, Justice Breyer referred to draining the swamp in terms of a swamp. And that the idea that this phrase had some other connotation, some other meaning that someone somewhere might recognize, totally out of his head. He had no idea that someone might have used that phrase for some other point. And that was, again, one of the delightfully charming things about that harmless institution, the Supreme Court.
Well, unfortunately, the atmosphere in the courtroom that Jess described, including Justice Kavanaugh's first day, most Americans will never get to experience, because if they don't visit the court doesn't allow cameras in the courtroom, and so most of America is not going to have that experience. When I look at the court right now, I think it's a very challenging time for the Supreme Court, mainly because of the Kavanaugh hearings and how there's so much hyper-partisanship surrounding the hearings, as well as the nominee himself contributing to that. And so a lot of people are thinking, okay, well, now we have a 5 solid conservative majority on the court because we don't have the swinging Justice Kennedy anymore. So why is it a challenge? I think it's a challenge for John Roberts in particular. I think he is an institutionalist to a degree more so than the other justices on the court, meaning that he really does care about how Americans perceive the Supreme Court. And as Justice Kagan said here, I believe not too long ago, that the court's legitimacy really depends on how you and I believe that they're making decisions with a certain amount of integrity. Now, there's a lot of rumor, discussion, debate going on about John Roberts. Now that Kennedy is gone, is he going to be the one who sort of moves to the center or becomes the median justice? Will he be the one who puts the brakes on how far and how fast the court moves to the right in certain areas of the law? I think that's possible. We saw a little bit of that several terms ago with the big challenge to the Health Care Act, and then a follow-up to the Affordable Care Act. He was key to upholding that statute. On the other hand, there are certain areas of the law that John Roberts feels very strongly about, and I don't see him moving much, even if it's going to result in a very controversial decision. And I think one of those areas is race in particular. He authored the huge voting rights decision, Shelby County, that eliminated a key portion of the Voting Rights Act. And I also think he is now probably the fiercest defender of the First Amendment. I think Justice Kennedy was as close as we came on the court to a First Amendment absolutist. The Chief Justice is very strong in saying that you have free speech, even if it's speech that you and I really hate. We just it makes us sick to see protests outside of military funerals with signs that are full of hate. But he will apply the First Amendment to those areas. So I'm not so sure how much of a center of the court he's going to be, but I do think that he might revert to how he was when he first became Chief Justice. And that was in certain areas, he took small steps before a big step came. In fact, he was accused at one point by Justice Scalia of faux minimalism. So he might, because of the hyper-partisan atmosphere that we're in right now, with the election coming, the court being the center of many people's focus, that he might want to go a little slower in certain areas. But again, he's got very strong feelings. So I'm looking now too at other justices and what kind of roles they may play. I'm very interested in learning more about Justice Gorsuch, who I think is very conservative. He calls himself an originalist and a textualist. And I think so far, when he has approached cases during oral arguments, he sticks to a textual interpretation, the words of a statute, the words of the Constitution, and then he does take an originalist approach in his writings. But I'll tell you, Yale Law's Akhil Amar, who calls himself a liberal originalist, once told me there are really only two kinds of originalists. There are principled originalists and there are political originalists. And he thinks that Justice Thomas is a principled originalist. Justice Thomas will take his originalist approach to the Constitution wherever it leads him. And often it leads him in places where he ends up alone on the Supreme Court. And political originalists, he felt, was Justice Scalia, who didn't always apply originalism consistently. So I'm interested to see, well, what is Justice Gorsuch going to be like? He had, in last term, done two things that I thought were quite interesting. One, he joined the liberal side of the court in an immigration case, and he wrote a concurring opinion that was really didn't have a whole lot to do with the majority opinion that he joined, but he wrote it specifically to answer Justice Thomas's dissent, which was all based on originalism. And Justice Gorsuch wanted to show how he took an originalist approach that led him to a different result. And he even said in his concurrence, I'm writing this because Justice Thomas has sort of thrown down a challenge, and I'm going to answer it. That was very interesting. And then there was another case that was so low on the radar, nobody cared about it except my peers who are predominantly lawyers and academics. It was a contracts clause case. I mean, the court hasn't had a contracts clause case in like 20 or more years. And what happened in that was that I think it ended up being a 8-1 decision, and Justice Gorsuch was the only dissenter because he took an originalist approach to the contracts clause and what the state of Minnesota could do when it passed a law that basically changed how your insurance beneficiary was determined under Minnesota law, whether that law could be retroactive. And he looked at the contract clause and he said, the contract clause, you could never make a law retroactive that would break a contract. And he was the only one who did that, and he took an originalist approach. Justice Thomas didn't join him, nobody else did. So I'm very interested in where he's headed and how conservative he may be. I think he's very conservative, but sometimes you're just looking for what seem to be these nuances in terms of what separates these justices. And then Justice Thomas, he's another one. If I had to come up with a word for Justice Thomas, I'd almost say he's radical, or maybe the better word is he's a revolutionary. He throws out these bombs in his solo dissents or solo concurrences, in which he is saying, we accepted this line of thinking for so many years. I don't see where the Constitution allows it, and I think we ought to revisit it. I think last term I counted at least 6 areas of the law that he wanted to revisit. Everything from the reasonable per standard under the Fourth Amendment search and seizure cases. You know, he said that was made up by some lawyer the night before oral arguments in the key precedent. And actually, he's right, because I looked it up. It was a young lawyer who came up with a theory and argued it before the Supreme Court, and suddenly it became part of our jurisprudence and has been for years and years and years. And then he also threw out in a dissent, I think, or maybe it was a concurrence, it was joined by Justice Gorsuch, in which he said that Section 2 of the Voting Rights Act was really all that's left as the most powerful tool to go after voting rights violations. He said it doesn't apply to redistricting. And Justice Gorsuch agreed with him. And I remember reading some of the commentary around that, election law scholars saying it was totally wacko that he did that. But he's just throwing out these bombs, and you wonder, will any of them take hold now that there is a firm 5-justice majority? So that's the right side of the bench. And when I look over on the left side, you think, oh, there's only 4 of them. What can they do? Well, they have to work really hard, I think, to be able to get majorities on the closest cases. As an aside, we often forget that the Supreme Court has, maybe almost 50% of its decisions are unanimous, or 7-2 or 8-1. And that's a remarkable amount of consensus across the bench. But on those really close cases where the emotions and the thinking is very firm and settled, I think the left side has to work hard. And there, I'm looking at Justices Kagan and Breyer. And the reason I'm looking there is because the year that the court spent with the vacancy right after Justice Scalia's death, there was a lot of hard work, you could tell, to show that the court could reach consensus, even though the docket was, not all that high profile. But it seemed as though there was a core group of justices who were working hard to find areas of agreement or ways to write decisions narrowly that would avoid 4-4 divisions. And those 4 were Roberts, Kagan, Breyer, and Kennedy. And now Kennedy is no longer there. So will anybody else join? Would Justice Ginsburg or Sotomayor be willing to move in such a way to prevent 5-4 splits that are ideologically, that's an ideological divide that sort of feeds how we view the court as being more partisan or more political? I don't know. I look at Justices Ginsburg and Sotomayor as being very similar to, say, Justice Alito and Justice Thomas, being very firm in how they view the law and not as willing to compromise. But who knows? It's a very challenging time for the court. And I think each one of them does care about the institution and how it's viewed. But there are the lines that they will not cross. And that's what I'm going to be looking for as we go forward.
Great. Terrific. There's a lot of observations there, and I want to pick up on a couple of them. One thing I want to get back to is the role of originalism in this new court. So I'm going to wait to get to this point, but one of the big changes from Kennedy to Kavanaugh is that there is a conservative non-originalist being replaced by a conservative originalist. So I want to talk more about how that changes the dynamics on the court in a minute. I want to highlight a couple of cases coming up this term that I'm looking out for, and picking up on what Marcia just had said about coalitions. Each of these cases might break up the familiar 5-4 split. You'd have crossovers of liberals and conservatives joining. So I want to ask a question. How many of you have read about a double jeopardy case that threatens to allow Trump to pardon his way out of trouble. Raise your hands if you've heard about this case. How many of you believe that it actually represents a risk to Mueller's probe or opens the door to Trump and pardons? No hands are still up. Okay, so you've heard about it. Okay, so some people still have their hands up. Okay, actually, so there is a number of people who've heard. What was really fascinating to me was how our social media framed this particular case called Gamble versus United States and warned that this case was a danger because it would allow pardons. So and then there was a second theory that was going around was that the Republicans needed to get Kavanaugh on the bench as fast as possible because he had to be on the court to hear that decision and be the fifth vote to help Trump get his pardon out of power. So I wrote a piece. I had actually been writing about the problem of double jeopardy as a threat to the Mueller probe about 6 months ago, and I was writing about how New York had a statute that allowed for that had its own double jeopardy rule. And the reason why this was a threat to the Mueller probe is that if there were a trial in which there was a guilty verdict or a guilty plea on the federal level, and then a pardon came down for Cohen or Manafort or Flynn, then there would be no remaining pressure to force that defendant to cooperate because there'd be no state backup, there'd be no safety net for a state like New York or Virginia to bring charges against that individual. But part of the point of the fact that states had this rule already meant that Mueller was already having to strategize around that problem. So not only did New York have this rule, and New York is a pivotal state, key state for many of these defendants, especially Cohen and Manafort, but New York had this rule, Pennsylvania had this rule, Virginia had this rule, California has this rule. So eventually, what became clear is that there was a risk that the states already had double jeopardy limitations, and Mueller already had to strategize his way around it. So whether or not the federal rule through a case like Gamble would extend it nationally, Mueller was already dealing with this problem, and he already resolved it. And one change from my view about this double jeopardy problem from last spring and then through the summer is that then their guilty pleas and cooperation happened. So Manafort pled guilty and is cooperating. Cohen is cooperating. Flynn is significantly cooperated, so much so that they are willing to schedule his sentencing in December. So my view is that Gamble is irrelevant now to Mueller's probe, and a lot of concerns were, I think, grossly exaggerated. And in fact, rather than, I think, liberals being anxious about double jeopardy being protected for defendants, we should be embracing Gamble, right? We should take Gamble on Gamble, if you will. That really it's actually to say that the Constitution protects against double jeopardy. What happened in Gamble was there was a citizen who was arrested with a gun. He was a felon, and there are both state and federal rules against felons possessing guns without permits. He was first tried in Alabama and convicted, and then he was tried in the federal courts and convicted. And this seems to actually go against the core notion of double jeopardy, that you shall not be twice held in jeopardy for the same elements. So whether you're a big purpose Fifth Amendment believer or a textualist or originalist, there seems to be a problem if both the state and federal government can sentence you. And the theory was called dual sovereignty, that the state government and federal government are two separate sovereigns, so it isn't double jeopardy in some sense. Well, the Constitution has changed over 200 years. The 14th Amendment has changed the way we see the relationship between state and federal government, that they aren't two totally separate spheres. The federal government has a relationship with the state government that is different from separate sovereigns. So I would say in the 21st century, we're looking back to the 18th century, I think we should be open to a case that will extend those protections. So that's Gamble on the Supreme Court's docket, and we'll be hearing it in December. And one observation there is I expect that case was going to cut across ideological lines. I would expect a judge like Ginsburg, justice like Ruth Bader Ginsburg, to see the defendant's rights at stake there. And I would actually expect conservative justices with an originalist perspective to understand the core notions of double jeopardy, and there might be an interesting mix of left and right. Another case is called Timms versus Indiana, about an Eighth Amendment protections against excessive fines. So there was a man who was convicted as a heroin dealer, and he paid a $1,200 fine, and the maximum for that conviction was supposed to be $10,000. But the state of Indiana used civil forfeiture to civilly seize his car, which had a market value of $40,000, which is a lot more than what should have been the limit of $10,000 for his conviction. There are many people on the left and right, libertarians in particular, who find that the power of civil forfeiture over property is a violation of due process and is a violation of the Eighth Amendment. So there is, again, a possible convergence of conservative libertarians and liberals who are worried about the state power over defendants to find common ground to extend the Eighth Amendment in a case like that. Another observation is that on left and right, there are more judges in the lower courts who are criticizing a doctrine called qualified immunity. What that doctrine is, it's a limitation on citizens' ability to sue the government for damages. There's a protection, immunity for government actors, whether they're police actors, for police violence was one example of using their discretion, or other kinds of government agencies being immune from the consequences of their actions. There are a mix of libertarian conservative judges on the bench who are writing decisions that are breaking through questioning qualified immunity by saying, look, not only if we really believe in libertarianism, that also means protecting citizens from the torts and wrongs of the government. And so liberals and libertarians might converge there as well. Coming back to another case that was just argued last week, a case called Nielsen versus Priap, highlights a question about presidential power and also shows a split between the two most recent justices to be appointed, Gorsuch and Kavanaugh. The case there is about whether the government is authorized or even required with individuals who are in the country legally but then commit a felony and are subject to deportation. And the question is whether the government can hold a person indefinitely without bail when they're subject to deportation without any bail given. And so what Justice Gorsuch said in oral argument is he said this is an extraordinary amount of government power, that you could hold someone after conviction, and in this particular case, this person had served his full term in jail and then had been released and had been out in the world for a couple of years, but because he was subject to deportation, he was rearrested and could be held indefinitely until deportation without any possibility of leaving detention. And Gorsuch said that seems like too much executive power. Kavanaugh answered, he said, well, Congress knows that the president has this kind of power, and because that's the default assumption, when Congress didn't add anything into the statute to give recourse, they knew what they were doing. So there you can see, I think we're seeing an early sign, if you want to read tea leaves, I think we're seeing an early sign of Gorsuch as maybe having some more libertarian instincts from the conservative side, some concerns about too much power either for Congress or too much presidential power. As Kavanaugh has shown at least an inkling that he's embracing presidential power. And I have a worry long term. It's that Kavanaugh will be the justice that is going to push for more and more presidential power from the bench. And my hope is that Gorsuch then follows through. Marcia mentioned one case of Gorsuch as showing some libertarian instincts. My hope is that Gorsuch continues to show those signs and is more of a libertarian conservative on the bench, drawing from originalism. The last point I would want to make is that just we shouldn't fear gamble from the left. I hope we shouldn't fear originalism from the left. Marcia mentioned the difference between political originalists and principled originalists. I would reframe that differently. I think there's a difference between narrow originalists, who, one way one could be a narrow originalist is to say, well, what did the founders expect out of these words from their 18th century view? That's narrow originalism. I think there's a way to think about originalism, and many people think about it this way, as a broad purposive originalism. What were the bigger picture, what were the big purposes in the minds of Hamilton and Madison and the framers when they put these words into the Constitution that reflected big, broad concerns about corruption. So I'm working on the emoluments litigation against Trump. The emoluments clause could be read super narrowly, but when you really read the history and understand what the 18th century founders were worried about, they were worried about foreign influence and corruption. Well, it turns out that's a broad goal, and it has very specific resonance today, right? Think about the murder of Khashoggi and authoritarians being able to murder journalists. Well, why would a president not be concerned about trying to crack down or get to the bottom of what happened? Is it possible that there's some corrupt influence over our government through other countries using emoluments to buy influence? And so this is a broad understanding that Hamilton and Madison and the original framers understood. So broad originalism means understand what the purposes of the framers were. These words meant something broader than just their narrow expectations. And I think liberals who are arguing these decisions, are arguing cases before the Supreme Court, need to incorporate originalist arguments more than ever before to win over some of these libertarian conservatives on the court, as well as liberals, to see these broad purposes in our original Constitution.
I'm confused over all these different types of originalism. And I'm sure everybody else is. So I have a question for you. Sure. Last night, I had an assignment to listen to Jeff Sessions, our Attorney General, who gave a speech at the Heritage Foundation. And the substance of the speech was not what I'm going to question you about, because he was very angry at federal judges for a whole litany of things, basically not giving proper respect to the executive and legislative branches of government. But he said at the beginning, he was extolling the fact that we now have on the bench Gorsuch and Kavanaugh and Thomas. And he said, for the first time in our lifetimes, we have a majority of justices who espouse originalist principles. And so I started there thinking, okay, who do we have? We have Thomas, we have Gorsuch, we have Kavanaugh. Who else would you really claim on the bench is an originalist? Now, some might point to the fact that Justice Kagan, during her confirmation hearing, said something to the effect, we're all originalists. Justice Stevens, who's now retired, when I once asked him about this, he said, well, every one of us starts with the text, either the text of the statute or the text of the Constitution. So I guess they're all originalists. But I think it just confuses. You talk about narrow originalism and broad originalism. And you talk about what was their purpose? Well, how different is that from what their original meaning was? How different is it? And do we have a majority of justices who truly are originalists?
It's a great question. I mean, there have been evolving arguments about how to understand originalism. So right. I would say the most sophisticated and the one that's the most legitimate is the one that many conservative and liberal professors agree about, which is called original public meaning.
Right. So
the reason why original public meaning is different from what came before. So some people call it originalism 1.0 was the Reagan-era Mies approach of, the founding fathers, specifically founding fathers, didn't think about equal protections for women. The 14th Amendment in the 1860s was not meant to embrace women, and it wasn't meant to desegregate the schools. They segregated the schools. So if you look at the original expectations of the framers, either in the 18th century or the mid-19th century, that's how you would think of the Constitution. Now, that view today, most originalists reject from the left and the right. These are not statutes that are meant to enact certain specific policies, right? Chief Justice John Marshall way back when said the Constitution doesn't have the prolixity of a legal code, which means it's not supposed to have so many words to spell out all of the specific policies. They're general principles. So if they're general principles, you don't take the expectations with regard to sex and race or other specifics. You think about the Constitution being written as a constitution that is supposed to govern over generations. So if the founders used word like equality, they understand that that word equality is going to be interpreted in the future. They're punting. They know that they're punting. So the framing now is that you take the original public meaning, which is different from the expectation. The original public meaning is manifest not by the authors of the words in Philadelphia, right, when they wrote the Constitution behind closed doors in secret. The original public meaning comes out in public debate and ratification. So one thing that historians, so this is something I've been doing over the past couple of years, is studying the ratification debates, where you get many more sources, many more people who are actually making the Constitution law. The Constitution does not become law when it was written in Philadelphia. The Constitution became law when it was ratified by the public. So that's one step that gets more democratic. How the Constitution becomes law is the source of originalism. But the bigger point is when the framers use words like due process or equality or privileges and immunities, they understood they were giving to future generations words that they would have to apply from a certain root. And so those are the broader purposes that are being handed down. So I would say Justice Kagan is someone who takes that originalism seriously. Now, one difference between, I think the question you're raising here is the history the only thing that matters?
Right, exactly.
Scalia once said, and you mentioned that Scalia is a political originalist.
Right.
Scalia called himself a lighthearted, not a lighthearted,
Faint-hearted.
He was also sometimes lighthearted when he wasn't being too menacing with his pen. But the faint-hearted originalist understands that you start with the text and context, but that isn't the only thing to look at in the world. Just like Scalia sometimes looked at other factors, I think someone can be a broad, I'm going to shift it from faint-hearted originalist to a broad originalist, where the history matters, even if it's not the end of the conversation.
It just seems to be getting closer and closer to living constitutionalism. You have someone like Breyer who talks about purposes and text and history, and I mean, I think it's very confusing for people, and yet you're seeing now I think very aggressive examples at law schools. I was reading recently about Georgetown is going to have an originalism camp, and I think there's another law school that's going to have an originalism camp, and some of your think tanks are having a special program for how to be clerks. And it's a conservative think tank that is firmly behind originalism and interpretation of the Constitution and text. So there is a belief, as our Attorney General said last night, that they are winning the battle. There is a battle or struggle over how to interpret the Constitution and statutes. So it's something to be very much aware of, what is happening. And, it's certainly worthy of research study as you're doing, and also watching what the Supreme Court is doing. But I don't think Justice Ginsburg or Justice Sotomayor would call themselves originalists of any kind.
Did anyone here ever see the movie This Is Spinal Tap? Because whenever we talk about originalism, I think about the early interview where they say, the band was originally called The Originals, and then they found that there already was a band called The Originals, so they changed their name to The New Originals. and that's sort of what we are with these different brands of originalism. I think it's pretty clear, though, on our court that certainly Justice Alito and the Chief Justice are not originalists. I mean, they are conservative, but I mean, I think Justice Alito made that point quite
painfully
in a case some years ago about First Amendment protections for violent video games, where he sort of scoffed at Scalia and said, so we're going to ask what James Madison thought about Grand Theft Auto. That it just seemed to be him kind of an irrelevant question. And that highlights another thing that we have seen, particularly on the right wing of the court, which is that they have often reached the same result through as many as 3 different paths, with a a Thomas Scalia approach when Scalia was around, kind of a Kennedy approach, an Alito Roberts approach, or Roberts on that. So they often, both when they were in the majority, found different ways to get to an end, and even when they were in dissent, they couldn't agree on who was more wrong, where you'd have 4 different dissents, from, say, the Obergefell marriage case. So that is one thing as well, whether the doctrine of the right wing of the court is able to coalesce around anything. I mean, Chief Justice Roberts said at his confirmation hearings, and he's mentioned it occasionally as well, his preference in theory for a broader consensus, trying to get beyond 5-4 votes to 6 or 7 or even more around a particular result, and how that may require a less ambitious outcome in order, the more votes you get, the narrower it is, because more people can agree on a smaller set of concepts. I asked Justice Alito once if he agreed with that view, and he said that he thinks it's important to have 5 votes around a single theory, but beyond that, didn't really concern him too much if there were 4 dissenting votes. And he framed it, though, in a very, not in a sort of, we got the power way. I mean, he framed it in the sense that it's, misleading to say that people, thoughtful people, there's only one right answer that everyone has to agree with. I mean, these are complex things, and you can be, you can have an approach that some of us disagree with, that you should be able to lay out there. And we have to pretend that there's only one conceivable outcome, parenthetically, even though majority opinions seem to suggest there is. The talk about originalism is interesting, and yet, for the political aspect of this debate, I think it was worthwhile to note what was the term that Senator McConnell, the majority leader in the Senate, used when talking about the nominees that he was so happy to ensure the confirmation of. He didn't call them originalists. He called them strict constructionists. Now, that is a term that was, popularized by President Nixon in the 1968 election when he was campaigning against what he suggested were excesses in the court. And that was how he described William Rehnquist when he was nominated in 1971. In any event, and so that suggests that for whatever the philosophical theories or doctrines or interpretive methods that are used to describe these legal actions, for a lot of people, powerful people, it's not about just a method of interpreting the court. It's about outcomes to a degree. And I guess you could say strict constructionism is a method in which you construct, but it's really not used in law schools now, too. That's not a term that's sort of...
No, in fact, Justice Scalia vehemently rejected that term, saying, don't call me a strict constructionist. It's just too rigid. I'm not even sure Senator McConnell fully understood the meaning of strict constructionist. It may have just been a hangover from the Nixon years.
It's a good soundbite.
Right, exactly.
But here's when we talk about originalism, there's sort of there's an Achilles heel to the theory. It came up at the Kavanaugh hearings, and that's called Brown versus Board of Education, which is a case 9-0 case that Chief Justice Warren wrote shortly after getting on the board, that all the justices joined. And it's very, some people think that racial equality maybe was not one of the original public meanings of the phrases in the Constitution, even the 14th Amendment, which was adopted when the Congress, congressional public galleries were segregated. And it was interesting to see that Brett Kavanaugh talked about that case during his confirmation hearings as the single most spectacular moment in Supreme Court history, and he encouraged everyone to go and read the decision and see how the court really applied the the text of the Constitution in that case. And many people have read that opinion and can still today. And the interesting thing is that the opinion explicitly rejects original meaning. It explicitly it invokes basically everything doctrinally that at least some conservatives find objectionable about what courts can do. It says, it may be true that when the 14th Amendment was adopted, racial segregation was the way things were. But we know a lot more now, and we know that that's, not acceptable, and it sort of lays that out. And it also relies on social science data and social science research about the effects of segregation on black children. Again, not a factor that would have been foremost in the minds of Madison and George Mason and so forth in drafting the Constitution. So it embodies many of the approaches looking towards these broader concepts that Jed was suggesting, and is quite conscious about doing so. And that was interesting. So I wrote an item saying, interesting that he mentions that case because it seems to be very contrary to a lot of the methods that conservatives approach. And then I quoted some of the criticism of Brown v. Board, which talked about justices are making it up. They have their own preferred outcome about how they want to reorder society, and they have their own personal agenda. And this is not what the Constitution's about. And that was, all things I took from the Southern Manifesto, which was written and adopted by Senator Russell, whose name for now is on the Senate building, and other, mainly Democrats from the segregationist South. And their critique is very similar to some of the things that is sometimes said about the court by conservatives. But I wanted to mention though another thing. You talked about the legitimacy of the court and whether what Roberts might do in moderating some of those conservative impulses. I mean, the premise of that though is that to remain legitimate, people who you think are dead wrong have to be appeased in some way, so they don't feel they're being totally ignored or thrown under the bus as the court moves in a particular direction. And I think that many of the conservatives do believe that the court already was illegitimate by making a lot of decisions, such as most recently the same-sex marriage decision and others, that they feel has lost its legitimacy. So from their point of view, why do they have to moderate getting it right in order to be legitimate in the eyes of people who are so wrong? I mean, that would mean that, and that, so he may, I'm not taking sides on that, but their whole complaint has been the court has done things in many areas that are illegitimate to begin with. So why should they, now that there may be 5 of them who are on board to correct, say, Roe v. Wade, that many of them believe is a tremendously wrong decision that itself damaged the court's legitimacy, why do they need to tolerate it any longer than necessary?
Well, what I was saying was that it depends on, whether Roberts wants to move quickly or slowly. I mean, I'm not saying he wouldn't want to make those moves, but if you suddenly get, and many of them have said this, if you suddenly get a new justice on the bench and that justice becomes part of a majority that begins to either overrule longstanding opinions or announces new doctrines that have the potential to divide the country, then you do look political because it was because that one justice who had a certain point of view joined the bench. And that does, I think, from the court's perspective, that does harm its legitimacy.
So can we take some questions
yes.
while you're finishing your thought, if you'll start coming to the
I
microphones?
wanted to say about when Jess was talking about structural aspects of the court, we tend to focus a lot on the decisions and, was it 5-4, was it unanimous, et cetera. But it's also important to realize how the court sets its agenda, which is in deciding what cases to take and add to the docket. And there you need only 4 votes. And so even though, say, Roberts might have a desire not to leap into some very controversial cases right now, given the election year and everything else, It only takes 4 votes, and now there are 4 other solid conservatives who may want to do that. So there's lots coming towards the court that could pull it once again to a very high-profile term.
AJ, introduce yourself.
Hi, I'm AJ Sibley. I'm a senior in the politics department. Well, thank you very much. I'm concerned about a newfound era of political entrenchment, given that we have now money being free speech, corporations being people, and as far as Justice Roberts is concerned, race not playing a role in politics anymore, despite what North Carolina and Texas are trying to do. And so I'm wondering, do you see this as a potential era in which the political elite of today can maintain and solidify their power in a way that's atypical for America?
So I'm going to say something a little bit maybe controversial, which is that Citizens United needs to be seen in a larger context. We need corporations to have rights. So if the press, if corporations like newspapers and cable news aren't treated like corporations, then they don't have First Amendment rights. So the New York Times versus Sullivan, the famous case from 1960s where Alabama tried to punish the New York Times for publishing an advertisement about the civil rights protesters. If the New York Times didn't have First Amendment rights, then there would be no problem with a crackdown of a massive damage award. So the larger point is that the problem with Citizens United isn't that corporations have free speech. The larger problem with Citizens United is being able to see things in a balance of constitutional values of free speech, balance with anti-corruption values. So this goes back to originalism. We can't be absolutist about one piece of the Constitution, but ignore the other pieces. The Constitution has purposes of First Amendment free speech, political speech, but it also has principles of anti-corruption. The example is the Emoluments Clause. So my view is Citizens United was wrong, not because of corporations having rights, but because it didn't balance those rights against anti-corruption values. So that's a quick answer for a piece of your question.
Let me just say one point. Of course, one reason that New York Times Company or Dow Jones and Company have First Amendment rights is because the First Amendment explicitly grants them to the press and not to other corporations. So I think that's that argument is certainly is, I guess, buttressed if they also have rights as corporations, but there is a particular carve out in the First Amendment that looks at that already, and so I think that it was really the press clause rather than generic corporate rights that the Supreme Court has looked at in times v. Sullivan. So I'm just defensive about that, I have to say. I mean, Scalia, who always said that every word has to matter, it seemed to be that was the one word he thought didn't matter because he felt that the word press was just redundant with speech in the First Amendment. So there we go. By the way, our code of conduct does not permit journalists at Dow Jones the Wall Street Journal, to take positions on political issues, except for freedom of the press. So I just want to be clear that I'm not straying from our rules. The other thing, AJ, though, I wanted to say to your broader question was about this idea of entrenching power through particularly federal judicial appointments, people who will hold office long after the current people in power are gone. I don't think that actually is ahistorical. I think that's actually been what generally has happened. I mean, for instance, you look at the Supreme Court's role for most of its history, I think, has been as a retrograde actor. I mean, during the 1850s, when there was a lot of ferment and the abolition movement and the original Republican Party, if you will, Lincoln and so forth, it was the Supreme Court that worked to entrench slavery through the Dred Scott decision, and there was a huge backlash, obviously, in the Civil War, which, then in the Gilded Age, you had the Supreme Court in the late 19th century really taking very aggressive steps to protect business interests and corporate rights then, and that provoked kind of a backlash of the progressive movement and even amendments to the Constitution to allow senators to be popularly elected and to impose an income tax. And then again in the New Deal era, where you had the Supreme Court frustrating President Roosevelt's program until they finally changed their course. So historically, many periods, if not the majority of our history, the Supreme Court has acted as sort of a brake on more progressive movements. So I don't know that it would be that unusual. One thing, though, that some historians have pointed out is that the Supreme Court, when it is acting in concert with a popular majority, tends to be more aggressive, as it was in the 60s when the Congress is more liberal, you have more liberal, at least on domestic issues, president. The Supreme Court was also moving that direction. When it is in opposition to the popular government, it may be more cautious in where it chooses to act and how it acts if it believes it is in tremendous, if there is it won't want to be at war with the popular branches, I don't think.
I think, too, in terms of entrenchment, so close in the midterms, vote, register and vote. There are consequences to presidential elections. You've seen it played out vividly right now, not only in terms of the Supreme Court, but in terms of all our federal appellate courts. It's been amazing what Trump and the Senate Republicans have been able to accomplish in less than 2 years in terms of placing certain types of judges in the federal courts. So I just would urge all of you, if you haven't registered, vote. And then there's also a very active debate going on right now that probably is not going to go anywhere and was triggered by the Kavanaugh confirmation, and that is, reconsidering the Supreme Court. The Constitution does not set the number at 9. Maybe it's time to think about, maybe we need more. Maybe we need term limits. Maybe we need court balancing is another proposal that's out there. There are a bunch of proposals that are being debated and talked about, and probably will go nowhere unless maybe Democrats, take control of the House and the Senate.
Didn't Chief Justice Roberts used to think that an 18-year term limit was a good idea?
Yeah, he did once say that. Yes, exactly.
Then I remember that was when he worked in the White House in the early 80s, and then when he was asked about it at his confirmation hearings, he said his views had changed on that. He'd begun to see the value of
Life tenure.
Yes, sir. Would you introduce yourself?
Thank you. That was going to be my question. What do you people think, given that all Supreme Court justices have lifetime tenure, what do you think, given the toxicity of the Kavanaugh confirmation, about establishing term limits for Supreme Court judges? Thank you.
So first of all, I think we have to take off the table, as practical, any change that needs constitutional amendment. Right? I think we have to focus on the kinds of changes that we can get through statute. So there has, actually this is an example of where originalism is important. So recently there were a number of commentators who noted that the Constitution doesn't say life tenure explicitly. It says judges will have tenure during good behavior. So there was an author who wrote something in the New Republic last week that said, well, it just says tenure during good behavior. We could change that to tenure to just a short number of years during good behavior. Well, that doesn't stop the Congress from, let's say, saying you can serve for 1 month during good behavior, and we could just reconfirm you every month, right? So the problem is that the Constitution will break down, both as a structure and its original meaning, if we try and convert without a constitutional amendment. Say that anything short of life tenure is meant by tenure during good behavior. So that's one point. The original meaning of tenure during good behavior, if it didn't have a number attached to it, was life tenure. So Jess, you mentioned Spinal Tap. How many remember that line from Spinal Tap where I think it's, David St. Hubbins has his amp, and he says, well, the amp goes up to... No, Nigel Tufnell. Thank you. I'm glad we have an originalist for Spinal Tap. So he says, look, my amp, other amps go to 10, but this one goes to 11, right? You remember that line? So the Supreme Court could also go to 11, right? And so the question now is what should trigger that politically? And I agree that it's important to have this debate about increase the size of the court. I think it's actually time to increase the size of the court regardless of the politics. 9 is too few in the 21st century when life is more complicated in terms of science, in terms of all of the interdisciplinary approaches. If we're going to have originalists on the court, it'd be nice to have some historians. I mean, I don't think I'm confirmable, but you know, it'd be nice to have someone who is actually an expert in history, as long as everyone pretends to be originalists, except, you know. So I think it's independent that we should have a larger court.
Would they all have to? Would they all have to serve? Would they all have to hear every case, or might you create a bench like in the circuits?
So it is possible that there's no rule in the Constitution that says, you know, that you couldn't have a system of panels. So these are design questions that could come up by statute. The question is, though, that you'd have to, if you're going to get a statute that would increase the size of the court, it would have to get through by statute, and it'd have to get over a current filibuster rule. I think the filibuster's done. I think we just, on the left, my view is if you come in with a new president and a Senate with 51 votes and members of the House, and the Roberts Court doesn't see its legitimacy as being compromised by pushing right. So I would say it's not automatic. I don't think the Kavanaugh appointment automatically means you have to have court packing. But if Kavanaugh and Roberts don't moderate the court's rightward direction, then I think 51 votes in the Senate plus a majority of the House should add 2 more justices to the court.
I'll just add one quick point on that. You know, after a certain period of time, federal judges can retire full salary. So if we move them right now by having Thomas, Ginsburg, Breyer, Alito on the court, we're really saving money because we have to pay them whether they're working or not. If you have 4 other justices, we're paying twice as much for the same amount of judging. So
Right. Yes, sir.
Walter Frank. I think one of the most neglected cases in terms of importance is the one that the court did about 20 years ago when they prevented the states from imposing term limits on federal officials, the Congress and the Senate. And I guess my question is really to ask you to sort of step back a little bit and even consider a lot of the things that you've been covering all this period. And the question is simply, assume a historian writing 30 years from now, what are the things that are at issue today that the court will face that will really affect the direction of the country and what we're going to look like 30 years from now?
Well, there are tons of those. I'll take the easy one since I'm talking first. One has to do with the effect of technology and the way that our ancient rights are applied in the new world. And this is actually an area where the Chief Justice has taken a particular interest. And of the cases last term, it was interesting to see that he, joined by the liberal wing of the court, found a Fourth Amendment protection for one's cell phone location data. There was a federal statute from the early 90s involving what the authorities need to do to access that information from a cell phone carrier. They needed a lower standard than probable cause from a federal judge. And the Chief Justice said, well, today, given the ubiquity of this information and how much it tells about you and where you're going, it really triggers the privacy protections of the Fourth Amendment. And he took a very similar position in a GPS tracking case several years before, and it seems that he is one who is particularly concerned about that application. Now Justice Kavanaugh mentioned that at his confirmation hearings as well, that application of constitutional rights to very fast-moving technology will be one of the big challenges for the court going forward.
I think there are maybe 2 areas that 30 years from now the court will still be probably dealing with. One is the role and the growth of the administrative state, and that's all of your federal regulatory agencies and how much power they have. What is their relationship to the federal courts? Can the federal courts rein rein them in if they get too big. Right now, the court itself is thinking a lot about how much deference it has to pay to agencies' interpretation of laws that Congress passed or agencies' interpretations of the regulations that they issue, all of which have, a tremendous impact on our day-to-day lives. We don't think about it, but it involves the environment, consumer purchases. So I think the growth of the administrative state is one. The other one that I think may still be difficult for the court is going to be immigration. We don't seem yet to have any coherent plan as to how to deal with illegal immigration, as well as what kind of society we're going to be as we are now changing day to day in terms of minorities who may well become majorities very soon. So I think their rights, the court is struggling with what rights immigrants have, illegal immigrants, and how the power of the federal government versus the power of state governments to deal with immigration. We're seeing that being played out right now in some of the litigation that's moving towards the court involving the so-called Dreamers, a citizenship question on the census. So I think those two areas will still be with us.
Just to pick up on the administrative questions about administrative power, one thing that and Jess also wrote a number of pieces about this question too. There is sort of a hidden movement that did not get enough attention in Kavanaugh's confirmation hearing, which is the status of independent agencies. So I'll give you one example that's been in the news. It's a major one. The Fed, the Federal Reserve Board, about setting interest rates. Basically, if the president had control over the Fed, that president, hypothetically, could manipulate interest rates for his own enrichment or for his own reelection. In fact, Trump basically said that explicitly, right? He's angry at the chairman of the Fed because he's not helping Trump out. Well, guess who also has questions about the independence of agencies? Brett Kavanaugh, and he's written as much and denied it and lied about it in his confirmation hearings. So the agenda, my belief now is that we have almost we have 3, maybe 4 members of the Supreme Court who would overturn the validity, what makes some agencies independent from presidential politics and manipulation. If Trump gets one more pick on this court, I think it's his agenda to try and have someone who will vote to give presidents power over the Fed and other independent agencies. And I think that potentially is what is one of the biggest risks to American balance of power looking forward in the future.
If I can just throw out a lighter question to follow up, who relates a little bit to what was said. Who is the most media-savvy member of the Supreme Court right now? Who actually understands mobile devices and actually likes them? I mean, if you know, I'm just curious. And can say.
Not Breyer.
Not Breyer.
Just to follow up on something that you said with technology, I think one of the things that was so surprising maybe about Justice Roberts' decision in that Fourth Amendment case where he was protecting the cell phone data, and of course under the Fourth Amendment that was a criminal case, it's still indicated, and you use the word privacy. And in your discussion, all of you are talking about intention, expectation, broad interpretation. Will there still remain a right to privacy 30 years from now?
Well,
Or under this court? Maybe I won't say looking ahead, but looking ahead in the next 10 years, will privacy expand or will it contract? And will one of the arguments be is that the Constitution does not protect privacy?
There's this Fourth Amendment strain, and then there's also the Griswold versus Connecticut strain from the 1965 case that specifically said that privacy encompasses certain marital decisions. Roberts and Alito, if I'm not mistaken, correct me if I'm wrong, Marcia, they both were asked and specifically endorsed the Griswold idea of privacy, and they probably dispute that that encompasses abortion, because now you have another potential life involved. But when it comes to someone, I mean, they both said they were for it. Obviously, opinions change. I don't know that Kavanaugh got into that. I don't recall. Did he also endorse the Griswold?
He did. He said all roads lead to Griswold, but he was using that to sort of dance around the Roe question. And his writings, in which he was lauding Justice Rehnquist, who dissented in Roe, he said that Rehnquist had applauded Griswold.
Griswold being the right to contraception. For,
The problem is that during Kavanaugh said he looked to Justice White's concurrence in Griswold. And Justice White's concurrence in Griswold was not the majority. It did not look at the right to privacy the way Douglas wrote Griswold. So it was questionable what Kavanaugh was really saying about Griswold.
One last quick
and Jed also has a.
So I read the speech. I mean, the backstory is that Kavanaugh got left off of the shortlist initially when Trump was campaigning, and then when Gorsuch got the nomination, Kavanaugh wasn't even on the shortlist. So how did Kavanaugh get from off the shortlist to the nomination? He did two things. He gave a speech at the American Enterprise Institute in the fall, in September 2017, the speech that Marcia's mentioning. But speech goes further than simply coming out of the closet as an anti-Roe vote. He signaled that as clearly as possible. He went further than that, which was that he raised questions about the entire line of privacy arguments because he questioned whether you could come up with a right to privacy that wasn't, quote, deeply rooted in the other amendments. So the penumbra, he's basically questioning, I read it as not only saying that he was not on board with Roe, clearly not on board with Roe, he was raising questions about the jurisprudence that gets you to Griswold. So I think that's so. And then Kavanaugh also writes an opinion in Garza that says that the state is facilitating abortion by letting its doors open to have an undocumented immigrant get an abortion. So that's how Kavanaugh gets from being ignored to getting the nomination, is because pro-lifers read those things. Susan Collins did not read those decisions or the AEI speech if she thinks that Kavanaugh is not clear about what his views are on abortion. I think Susan Collins had some other agenda in mind. But if there are more appointments like Kavanaugh, then I think the right to privacy is a real question.
The last quick point is that this is basically, we do have two strains in privacy. One is the sort of personal choice privacy, and then the other one is your data and your information. And in that sense, I think the precedent to look at is Smith versus Maryland, a late 70s precedent that said that if you voluntarily give your information to a private third party, then you have no privacy interest in it. And that involved dialing a telephone and the police looking at which numbers you called to help track down the guy who stole a car. And now that the government has relied on that doctrine to use the massively different in scale situation of the private companies that operate the internet and the vast amount of data that they collect under the presumption that you voluntarily are, you know they're going to collect it, you're choosing to collect it. And the Chief Justice has expressed a great deal of doubt about whether, even though maybe in theory there are similarities, whether the scale is so vastly different that it can't possibly consider the same thing. We saw, Justice Alito and some of the other conservatives disagreeing in the Cell case because, law enforcement, that's incredibly valuable information for law enforcement as well. So I think that's like a separate strain almost, where the key case is Smith and its predecessors rather than the Griswold, Eisenstadt, et cetera.
Okay, we'll take one final quick question with quick answers. Yes.
Well,
question, and I don't know if I can reach. But in any case, you've spoken a lot about originalism, you know, in terms of all of the different justices and all, you know, slicing and dicing. But I'm not academic, I'm not a lawyer, but I always feel like it's a way of hiding behind. You can say I'm an originalist, so that's why I'm saying what I'm saying. Where are the great legal minds? They seem to be lacking. I just wanted to know what you think about that.
This is really hard stuff. One of my favorite sort of speeches was by Justice Souter. After he retired from the bench, he was up in New Hampshire, and he engaged in a conversation before, I think, the New Hampshire Historical Society. And he talked about the Constitution, and he said the language in the Constitution, in some cases, is very specific. We know that a president has to be 35 years old. But on the other hand, the Constitution also speaks in very broad language, like reasonable search and seizure. You know, what is reasonable? Even free speech, he said. You know, what does that encompass? So he said what's really happening at the Supreme Court is there's this tussle between the application of principles. And the Constitution doesn't always tell you. For example, in Citizens United, there's the principle under the First Amendment that corporations have speech rights. And that's sort of a liberty principle. And then on the other hand, there's an equality principle. Corporations have speech, but they shouldn't have so much speech that it drowns out other speech, individual speech. And he said the difficulty is in balancing and then applying these principles when the Constitution doesn't tell you how to do it. So then he was asked, well, how does the average person know, you know, whether the decision was right or wrong? And he said, well, you know, he said, you have to read the decisions, and you have to decide whether what the court said in applying a principle makes sense to you. Is it convincing? Is it persuasive? And that's how you make your judgment as to whether one principle prevailed over another. But it's not, you know, there's no magic bullet, there's no magic test. Originalism, constitutional, you know, living constitutionalism, it just comes down to you reading the decisions, as hard as that is. Some of them are not hard to read, but whether you're persuaded, even if you don't like the outcome, whether you think it was justified by the reasoning and what the court said. But it's always, he believes, this sort of struggle between principles and the application of those principles.
I believe no more suitors was a very common term, right?
Yes, it was.
Right.
And also was no more Roberts and no more Kennedys.
So if you don't read the text of all the decisions, you can read the analysis and the reporting by our distinguished panel. So before I ask you to join me in thanking them, let me first acknowledge and thank the LAPA staff, Jen Bolton and Judy Rivkin, and our director, Paul Freimer, for helping to put this event together. And second, I just want to mention that you all now have your assignment, and the next time anybody tells you that elections or the parties or who's running, there's no difference between them. The appointment process for judges with lifetime tenure will have long-term consequences that will outlive the individual that you're electing to the legislature or to the presidency. And finally, please join me in thanking Jess and Marcia and Jen for really. Thank you all for coming.